All right, the Public Defender Service Corporation Board of Trustees meeting. The final meeting of the PDS board is currently constituted. Will be called to order here on August 19th. Will the the administrative director please call roll?
Thank you, Your Honor. I'll roll for what I'm assuming is the last time I'll call roll for this board. First, we have Chairman, Chief Justice Robert Torres.
Present.
I understand the Vice Chairman is on his way. We have Attorney Jackie Sirlani. Member Donna Muñiz-Nasser.
Present.
And Member Dr. Cristiano Wood.
Present.
We have a quorum. 4 of the 5 trustees are present. Notice of the meeting was duly published in accordance with the requirements. And the first item on the agenda is the approval of the minutes from the July 22nd, 2025 meeting. There's been a motion. Second by trustee Talai. All those in favor say aye. Aye. There being no objection, these meeting minutes are approved. We have old business. I'm going to ask that we dispense with the old business now, and the reports can be given to the new board as they come up, and that we focus instead on the new business, which is the resolution on the recommendations for the continued continuity of operations for the private attorney panel. And also the retirement certificate presentation for Mr. Moreno. So if can someone make a motion to dispense with old business and move on to new?
Motion to dispense with old business.
All right, moved and seconded. All those in favor say aye.
Aye.
There being no objection, we will go so accordingly. So we're now under the resolution, and it's our last resolution from this board. We've seen a copy of this resolution previously, but it did not have many of the details, and we had asked them to go back and actually look at coming up with the draft proposals. And what it is we are going to, we have recommendations just to make the transition a little smoother, although we do have at least one member of this board who will continue with the new board, Dr. Whitman. But we had asked that we develop and prepare recommendations governing the administration of the private attorney panel division for our review, and gave them some guidelines for what to do. And they've now come back with recommendations for us to propose to the new appointed board, so the transition is a lot easier. And I'm gonna ask Steve, will you be the one to go through these and highlight them, or Shane, or who will go through the
I think
proposal?
we can start with the executive director to go through.
Okay.
So the first part of the proposed amended bylaws, we just made it consistent with the law that was signed into effect yesterday, Public Law 38/48. And so it changes the composition and the number of decisive form, etc. So it's pretty, no substantive changes were made other than to incorporate the new law.
Steve, what you mean is these are based on the PAP's old miscellaneous rules, right? I mean, they're.
No, that's, no, this is the
just
bylaws
our
he's
bylaws.
talking about.
And I think
Yeah.
we will need at the next one, at the first matter of business, so they can then elect a chairperson, probably a. And then, and then we'll, then it'll guide the first. So we just added that just so that you guys have an idea of the bylaws as though exist with the new board. But we did basically adopt more or less what the existing procedures. And that's where these proposed rules, starting with rule 1, contains. So the first one is the path where Previously, it was the standing committee of the private attorney panel. Now we're constituting the committee of the private attorney panel that will approve and review applications.
Did you turn down that chime, JT?
Yes.
Like,
Okay.
So they'll be using the same standards for approval as currently exist. And the advisory committee will consist of members from the PDSC, ACD, CLC, as well as one member from each of the private attorney panel. So it should have a committee of 7. I mean, one, like the felony and misdemeanor criminal will have 1 rep, the juvenile will have a rep, and then the appellate panel will have a rep. So it'll be 7 members, and they'll review all the future applicants. They'll also be handling appeals from when there's a denial of, if they want to exceed the cap. And so our rules also provide that.
and, go ahead.
So it also provides a procedure for adding or removing attorney from the panel. Or if there's a resignation. The part of that first rule also is a rotation where obviously PDSC will get all the cases first. If there's conflict, APD will be appointed. At that point, if APD has a conflict, the court can appoint someone from the list. And after that, we're hoping that we can do substitutions of councils with the remaining panel members so that we don't have to have this, like 3 months of continuous motions to withdraw. And they'll get attorneys on else, And so that's pretty much the proposal.
And the compensation for the private attorney panel is exactly what it is now, right? Under proposed rule 3.
That's
Let
correct.
the record reflect that PJ is here.
The legislature actually embedded that $150 rate in the statute. And so it'll be up to the next new board to reevaluate the rate.
Yeah, and even the caps that are currently exist are exactly the same. Right?
That's correct, because there's a mechanism for if they exceed the cap, should they go to trial and other rules like if they gets reversed and there's a new trial, let's restart the cap.
On the attorney panel, if an attorney is appointed, right, since we're going to be talking about them. If a person is appointed to public defender, but he's overqualified. But can a judge, in the past, sometimes the judges overrule that. And order that you proceed, can the judges do that still? So, but who pays for that, court or the immediate defense fund?
Well, so I know that the court has done that in some cases. We haven't, it's not really addressing the rules, but historically, we pretty much kept those cases. So I don't really see how that would, hopefully that will change. And it happens like in a protective order case where someone is facing, we represent them on the criminal side. Then a judge will appoint us on the protective order side so that they don't make any statement in the protective order side. That could be something.
So we can override the disqualification. Well, the AD, this is not qualified for the public defender AD service.
Yeah, we don't anticipate that.
So there'll be no penalty on the court or anybody.
Yeah.
You'll still take over. Okay, that's what I took. Some of the judges ask me, because we do that occasionally.
Yeah, especially for those, the protective order cases.
Yeah, there's a lot of borderline cases where, the overqualification like 2,000, 3,000. There's no way these guys can afford to go with 3,000 over.
Oh, exactly. That's what we're here for. So hopefully it won't be an issue.
Okay, great. So we just put that down in writing.
It'll be like a notwithstanding.
Yes.
And that's kind of, we'll put that in rule 2. Because rule 2 deals with mandatory representation, and then there is a discretionary one. And our judge say, oh, we're promoted that facing loss of liberty. So that's the protective order. We really left out, which is a kind of worms we'll go later, the ineffective assistance of counsel claims, because right now you can't really appeal it unless there's a record. And so we've been fighting that, they represent themselves. So they can go through, we can have a trial with an ineffective trial counsel, then their appellate counsel can bring it up. And so they have to sit in jail and find a way to file where the habeas on their own. And so it's kind of a gap
Yeah, it's kind of,
yeah.
running around in circles.
And then so there, some trial judges appoint us at the writ stage and some don't, and so it goes up to the Supreme Court. And then we get appointed to represent them at the appellate level, but there's no records to really argue, so you kind of have to ask for it to get sent back down. So we'll try to streamline that process.
Now, I noticed, and I just wanted to, well, one of the provisions that's in here is, on, if there's a denial of a claim, that exceeds the cap or an appeal. Right now, the way it's set forth, I think it's on page 47, the executive director will make the initial approval or denial of requests that exceed for payments that exceed the cap, and then they can appeal that decision to the advisory committee. That's what's intended.
Yeah, well, so that's a judgment call for the board to make. We'll give them the options of making the appealing, they can appeal to the board themselves or to this advisory panel. We just, like, it could end up being a lot of work for a board, so they might want
Yeah.
to let the
Yeah, I mean, I'm fine with as it is currently recommended, and let the board, decide if they want to change that. Jack, do you have any questions about the rules? I mean, they're pretty much the same current rules that are in effect. The miscellaneous rules, the forms. And where's the list of the current list of private attorney panel members? Is that in here?
I actually have it right in front of me.
Yeah, I know it's the January. We had seen yesterday. I thought it was also gonna be part of this, because it does reference it, doesn't it? In one of the rules?
Yeah, I don't think we actually got it, but there is a updated,
Do they have to reapply or?
No, it's
I
gonna,
think it's not positive.
it's gonna, all of the way the rule reads now, I mean, if you go to that rule, that's the, it's under rule, it's on page, 35 of 52. And, and it says current members as of September 30, 2025 will remain on the balance. So, I mean, that'll be the list, because that's the ending date for us, and any new member who wants to be added after that date will have to be approved by the PDSC. And any, one who basically withdraws will do that. Now, I just wanted to go again through the, the list here will be as of September 30, but it's keeping in mind, so when the new board adopts that, you've got the current list. I don't see it changing much between now and then, but I think there has been one or two that have expressed interest, and we will approve them until our duties, the court will. Our duties expire by statute on September 30th. We'll continue to operate and approve much the same way. We'll do all the billings and everything until September 30th. So that will, just go forward as it's currently done.
I have a couple of questions.
Sure.
Number one, the financial voucher, I notice it's not attached here, right? So the financial voucher, as it currently exists, requires the attorneys to break down the per court time and out of court time. And so that's always consistently been a problem, especially since the rate is now being scaled to one rate.
But I don't know if there's a need to break it down anymore.
Exactly. And that's my point. So any voucher that we use, I would recommend that we remove the court time versus out of court time. simply because it creates this problem like, currently, like right now, when I submit a voucher, they ask me, well, can you separate the court time? And I'm like, I get $150 an hour, guys. Having to separate this stuff is another hour. Yeah, exactly. I'd like to charge you another hour for that. And we don't, right? So, but that's the thing. I think that's one issue I think that's important for you to know, for your board to be aware of. And then on the compensation of Rule 3, there is a provision that's here that I haven't seen before on,
What page is that?
this is page 42, that there is an absolute cap of $30,000 on all attorneys for a first degree felony, irrespective of the number appointed. This is gonna create huge problems.
So I think this is an existing rule.
No, because right now the rule is that if John is first on it, right, as the first private attorney panel, and he exceeds 10,000, and I come on, I get a next 25,000. Right, so I'm allowed the cap of 25,000 because what John did, I don't know what John did.
Oh, yeah, no, that's so I think this applies when, two attorneys are appointed to this at the same time.
See, and
So like,
I don't, and see, just reading this right here, that's why I'm
but we
saying,
could have that clarified, that
Yeah.
shouldn't happen, like, for example, that was a big problem when you had people leave, right? They exhausted the cap, and then the new attorney was assigned, and they were,
Say simultaneously, if one of your
Yeah,
last two
it's
people on the
percent.
same case
But you see,
for the
that's-
trial.
but the thing is, our current rules, right, prohibit us. So if, for example, KB and I decide to work one case together,
Yeah.
it's one person billing, it's not two of us. We can't bill the court for both of us at the same time. And so I'm afraid that this particular provision is going to require not only a certification from your financial officer of what is available for the fund, and then we're going to have a process where the attorney can decline the appointment simply because there is no fund available, right? Which would defeat the whole initiative appointment. So I'm just saying that this provision is problematic. This is not what it exists today, right? The way that we process things.
there's anything to change.
Yeah.
So I think we,
Well, let's look at the language that's
Yeah.
there today, if we can pull up the
The rule,
miscellaneous rule.
yeah, of course, so I think it's for simultaneous, like, so you and Chris both were working on a first degree felony. Like, if it was just one of you, the cap would be 25,000, but, or 20,000 for first degree felonies. But if you two are both working together, then you can collectively go up to 30,000.
and that assumes, right, that the court has approved that process,
Yeah.
right? Because that's allowed where, for example, like a murder case.
Yeah.
Superior Court,
right?
Superior
In the
Court.
Superior Court,
There
yes.
you go. Miscellaneous.
Oh, yes,
rules right
please,
there.
thank you.
There you go. Up, up, up. It says miscellaneous rules.
Yeah, it is, it's under indigent defense. It's there, you can pull it up. I have it right in front of me.
Oh, yeah.
So if you go back up to the top, go back to the
Yeah.
top.
Oh, it's, would it be this one?
No, go back, go
to
back,
the main menu?
go back, and you'll drop down on
Supreme Court.
Supreme Court. And there's one that says indigent defense, right there.
Yeah.
That's the one.
Yeah, then it's right there's the rule, the first one.
The first one, MR one. One point 1.5.
It's not applicable, JT.
Compensation. It's exactly the same language, Jackie.
Oh, is it?
Yeah, for
I was
first
gonna
degree
say-
felonies in which the court appoints
Yeah.
more than one attorney, not
Oh.
more than 30,000 total shall be paid.
Actually, that's a little bit, not more than. Which one, more than one attorney is appointed, okay. So I was gonna say, I think that I've misunderstood this
Yeah.
one in context of the way we provided them.
Okay,
Okay,
so it's,
so long as it's clear that this
Oh, yeah.
relates to a multiple appointment.
It
as
is.
opposed to-
And it's a great way to train younger attorneys so that you can be paired with like the management from like your firm, and then you can both go.
All right.
Huh.
All right, any other questions on this? All right, so are we now ready to vote on this resolution?
Are we modifying the resolution to reflect that the bill has time? That the resolution.
We should,
Yeah,
yeah, we should change the first whereas. Well, I guess that's introduced, we just have to add another one.
maybe on the second to the last paragraph.
Yeah, we can add, whereas just the second, before the now therefore resolved. Whereas Bill, or just delete that, all recommendations are contingent, whereas. Bill 9738 was passed and signed into law as Public Law 3848.
Yep.
And these recommendations are therefore made after signing of the bill. Okay, so with that.
Motion to, to do the resolution, but with that correction.
All right, striking out that whereas and with the appropriate language, Shane's got the language down. And this will be the last official resolution I sign.
So it's been motioned and seconded with the amendment.
And I'd ask that it also be amended to have signed by the vice chair, since it's also, after all these years.
That's a nice amendment. Vice chair.
So be signed by the chair and vice chair. Token.
With a gold star.
All right, with those,
I want a gold watch.
that's what they told us. They told us they were
Yeah,
giving us watches
Yeah, they said
today.
they were giving us gold watches today.
All right,
Don't worry, we'll have the new board approved. something.
all right, with those amendments to the resolution, and first on the amendments, all those in favor say aye. Aye, there being no objection, the resolution's amended as such. And on the main resolution as amended, all those in favor say aye. Aye. There being no objection, those are the recommendations that will be made to the new board. Hopefully they listen to our wisdom, but recognizing that they have the independence and that was what the legislation was intended to accomplish. So, good job. All right, with that, the next item on the agenda is the retirement certificate presentation for an old fiduciary Guam employee, PDSC employee, Mike Moreno. And who's going to speak on this?
Well, I can do that. So we have a certificate of retirement for Mike, who's really been with us 15 years. I'm not sure how long we got for it.
About a year and a half.
Okay, so now he's gonna be retiring and officially and moving to the Philippines, so he'll be living the dream life.
Just pick us up at the airport.
See you in Manila.
In recognition of your 15 years of dedicated and loyal service to the Public Defender Service Corporation, we gratefully acknowledge your hard work, professionalism, and commitment. Wish you the best for happiness and success in the future. Thank you from the Public Defenders. We didn't have the board sign it, we signed it, so
That's fine.
but we'll, here's the certificate, Mike. And then we also have a cake for everyone, so, that'll be good. That's the official, that's the official business of the.
Icing on the cake.
That's the gold watch.
Thank you. When is your official last day, Mike? Oh, this Friday?
Friday, yeah.
Oh, wow. You're heading back to Manila.
It's a good.
Congratulations. Do we have someone, well, it's not my problem, it's the problem of the new board. You have someone coming in to help?
Well, we started that process already, but of course, once he's done his parent, we will put out the notice for announcement for his position, so. But our staff right now,
Carry it.
we've been prepared,
Okay.
well, not as prepared.
And
as
thanks to you, we'll have Ricky.
Can I speak?
On our board.
Yeah, Mike, any last parting words for us?
I mean, did you want to give your one last financial reporting? Seems like I didn't bring it.
For reporting, thank you everybody for your support and your confidence in me. Thank you for all of these years.
All right, a final motion to adjourn. Don Canal, you're done. Jackie?
Motion to adjourn.
Second, it's been seconded. Any objections? Last chance, PJ. There being no objection, we will now stand adjourned. Congratulations and thank you all for your work.
Trustee Whitman.
Dr.
Shall
Whitman.
continue on.
Yeah, it's gonna be
She will
like a-
continue
She is the only board member that is transitioning. So you stand alone.